Derek here from McKenzie Friend Consultants. Welcome back. Today I'm going to cover the second of my bonus videos, and that is the pre-trial review hearing. Now, you may well be here after watching my allegations of abuse videos, as a pre-trial review is typically directed to be heard before a fact-finding hearing. In fact, a pre-trial review may well be ordered before any trial or final hearing, and the principles are exactly the same. Now, before we get into this short video, I would like to request that if you find these videos of help, then please press the subscribe button below. Thank you. The objective of the pre-trial review, or PTR as it is known, is to ensure that everything is ready and available so that you can have an effective fact-finding hearing or final hearing. Now, I have attended final hearings that have been scheduled to last for several days long, and there hasn't been a pre-trial hearing. As a result, fundamental documents and reports are not available at the final hearing. It is therefore not possible to conduct a fair and reasonable trial for one or both of the parties. You may have been waiting months for that final hearing, getting stressed as the date gets nearer, and for that major decision to be finally made. You arrive at court and the hearing starts, and within minutes of the hearing starting, it becomes apparent to the judge that vital information is not available. The judge is placed in a really difficult position. Can the information be readily made available? In most cases, it can't. Can the court muddle through without such vital information? Well, it's very unlikely, and if it did, then either party would have clear grounds to make an appeal based on having an unfair trial. The judge has very little option other than to adjourn the hearing and cancel the next few days that were scheduled. He will then give clear directions of what is required by what date to ensure that everything is available for the new date of the hearing. He will then request a new date, and in most situations, the next available date, particularly for hearings lasting several days, will be many months away. What a total waste of everyone's time and money. And in the meantime, you have no decision made and very limited access to your children. Well, how did this happen? And surely this could have been avoided. The answer is that it could and should have been avoided. There clearly should have been a pre-trial review to ensure that everything was in line and available for the hearing. This unfortunately happens far too often. Therefore, if you have a fact-finding hearing or a trial ordered that is several days long, then I suggest that if a pre-trial hearing has not also been directed, then you ask the judge if he feels it would be helpful to have a pre-trial hearing. The pre-trial or directions hearing typically lasts for an hour or so, and by comparisons should be a pretty straightforward hearing. The PTR's objective is for the court to determine exactly what should be available for the final hearing and made ready in time to avoid an adjournment of that hearing. The court will decide what, if any, witnesses are required to attend, what additional documents and reports, such as police disclosures, social services reports, etc., should be available for the hearing, and what evidence the parties should be submitting. In fact-finding hearings, the court may also determine which and how many of the allegations are relevant to the case and should be heard at the final hearing. It's a very straightforward hearing. My number one tip is to make sure that you are well prepared and that everything that you need to assist you with your case will be available in time for your final hearing. Therefore, you must produce a position statement which clearly covers what you need to be available at the trial. State which of your witnesses should attend and which of your ex-witnesses should be made available at the hearing for cross-examination. If you have further evidence that you have not already submitted to the court, such as maybe video recordings, then request the court's permission to submit them to the court for the final hearing and have them available at the PTR for the court's consideration. If your ex has made allegations to the police, you were arrested with no further action and the case dismissed, but your ex is now regurgitating the same old malicious lies to the court, then you must ensure that full police disclosures are available at least a week or two before the hearing, as the content of those disclosures could be vital evidence to prove your innocence. And please note that police disclosures can typically take 6 to 8 weeks to be made available. Now, if you are a litigant in person, in a case with allegations of abuse, then you will not be allowed to cross-examine your ex. The court should therefore decide how the cross-examination of your ex should be conducted and how you will submit your cross-examination questions to the court. The judge will normally conduct the cross-examination on your behalf, and you will be directed to submit your questions to the judge a day or two before the hearing. This point is regularly overlooked, and if it is, then you must raise it during the PTR, otherwise it could result in issues at the final hearing. And that's really about it. In my next video, I will be covering the fact-finding hearing. So, stay tuned, and if you haven't done so already, then please press the subscribe button below. And if you'd like to chat about your case, then please go to www.McKenzieFriend.co.uk and book your free consultation with me. Bye for now, and until my next video. Thank you.